Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket for September 20th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives and being streamed live on YouTube for public viewing. Mr. Marufo, would you call our first case, please?
Top of page 1, Judge. Cause number 2019 DCV 1458, Maria Pina versus City of El Paso. Announcement of counsel, please.
Good morning, Judge. Matt Marcus for the defendant, City of El Paso.
Good morning.
Good morning.
Christina and Castle on behalf of plaintiff Maria Pena.
And so we were reset this case, having come back from the appellate court. We were set on the 16th, but I think there was at least some confusion about the last setting, so we just reset. Ms. Castle, do you have an update?
Your Honor, I spoke with Mr. Marcus yesterday, and I believe that all issues between the parties are now resolved and the court can close the case.
Were you going to file a non-suit, or do you want me to just dismiss it for lack of?
Whatever the court's preference would be, we can go ahead and get a non-suit on file.
Just put a notice of non-suit with an order and I'll sign off on it. Mr. Marcus, go ahead.
Yeah, Your Honor, I'm sorry. And so the 8th Court had dismissed the case for lack of jurisdiction. So maybe there was a little bit of a mix-up when it came down from the mandate. So that's why we were caught off guard a little bit. But so yeah, we're in agreement that the case is done.
Okay, so there'll be no further settings. Thank you very much.
Yes, ma'am.
Thank you, Your Honor.
Thank you.
Thank you. Who's next?
Second one, Judge, in cause number 2021 DCV 85, Randy Nakeda versus Lola Vanessa Rogers. Announcement of counsel, please.
Good morning, Judge Ashley Cedillo here on behalf of the plaintiff.
And Joshua Murphy on behalf of defendant Rogers, Your Honor.
Also, entry of judgment. How are we doing?
Your Honor, on this one, I'm just waiting for Blue Cross Blue Shield of Texas to get back to me. My client is an ICE agent, so they had some additional charges recently that were not related to this incident that we are in the process of disputing. So that way we can get them drafting instructions. I've already told opposing counsel if I don't have my dispute resolved in less than 30 days, I'm just going to pay the lien in full, which I've talked to my client about.
Okay, I'll go ahead and set you for October 18th at 10 a.m. Thank you.
Thank you, Your Honor.
Who's next?
And on page 1, Judge, in cause number 2020 DCV 4192, Victor M. Reyes versus Leona Cervantes and Gabriela Cervantes. Announcement of counsel, please.
Albert Beal here for Mr. Reyes, Victor Reyes.
Mr. Beal, how are we doing? We're at another status.
Yes, I just talked to the receiver. The property is in the process of getting sold. Mr. Reyes, I think, may want to buy the property and sell, but that's we're still marketing the property, and would ask for the court to give us a little more time.
Like something like 6 months, or what are we talking about?
Like 60 days, Judge, not 6 months.
Okay.
I want this off my desk too.
Okay, well, we've been, let's see.
I think
It seems like we've been here every 2 months, so sure, we'll go two more months. So
Okay.
November 15th. November 15th at 10 a.m.
Works for me, Judge. Thank you.
Perfect. Thank you very much. Who's next?
Judge, on page 2, I would like to ask opposing counsel if Mr. Doyle was going to show up on this one. Are we waiting on Mr. Doyle?
I don't know. I don't think so. Mr. Grajeda, I think, indicated that he had settled.
Okay.
Right. Yeah. I guess Mr. Doyle had something scheduled. I guess, Cynthia, you notified us that you were going to be in trial. So I guess he put something on his own calendar and asked me to stand in for him. But we have settled the case with his clients.
Okay.
I was in trial. I busted the jury. You wouldn't believe, Your Honor. The jury said that they would not. A lot of jurors said they could not follow the judge's instructions on reasonable and ordinary care for a physician because the judge was not a doctor.
Okay. Well, I may have seen a nice, I don't know what you call them, a meme or something you had put on Facebook that left me with a question mark. So that's part of that. Let's go ahead and call it, Mr. Marufo.
In cause number 2020 DCV 4223, Leticia Isabella Lawrence et al. Versus Tenant Hospitals Limited et al. Announcement of council, please.
Olga Heda for plaintiffs, Your Honor. Good morning.
Cynthia Yamas here for the defendant HCN.
Okay, and so I heard off record that Mr. Doyle, I guess things may have been settled with regard to his clients. We're here for a final civil pretrial. Mr. Grajeda, I'll start with you.
Yes, Judge, this is a medical malpractice death case. I guess because I know it's a 2020 case, Your Honor, but in med mal death cases, because of the damage caps, the plaintiff has to kind of be very careful before they spend a whole bunch of money on experts to try to get cases resolved. And Mr. Doyle and Ms. Yamas have been very considerate in that regard during the time the case has been pending. We mediated the case. We've now settled the case with Mr. Doyle's clients. And now I guess it's pretty clear that we're not going to settle the case with the hospital. And so we've provided dates to schedule the depositions of the 8 experts that plaintiffs have. All of them are out of town, as is customary in medical malpractice cases. And so what we really need is a special setting. We need time to depose the experts for sure. We obviously have to spend the money on that now. But we have provided dates on which they're available for their depositions, which we indicated to the court we would do in August. And we would respectfully request that this case be set for a special setting so that if the plaintiff and the defendant incur the expense of flying these experts in, we can be assured that the case will proceed to trial on that day.
Okay.
Hey, Your Honor, I'm more than happy and open to discussing settlement negotiations with Mr. Grajeda. I don't know why he said we can't. We couldn't at mediation, but I'm more than happy to negotiate with Mr. Grajeda. I actually had an offer to him, which was just outright rejected there. I mean, he didn't send a counter, but I'm happy to do that. And you did ask us before you moved the October setting to start setting depositions, which we've noticed. But I'm more than happy to talk to Mr. Grajeda about maybe trying to resolve the case before we incur those deposition expenses. He sent over some dates that he was available, and I've looked at my calendar to see when I'm available. The dates that he and I both have sort of agreeable on our calendar is June 17.
For a trial date.
Yes, Your Honor.
Okay. Okay, well, let's look at that. June, a little further. So we would be doing jury selection on, well, I haven't done this really in a civil case where I've done multiple days, but based on your comment earlier, Ms. Yamas, maybe we do need panels like we do in criminal cases. No?
I think that was just, there was one particular veneer member whom I think really wanted to talk, had a bit of an axe to grind, and he riled everyone up. It was just one person.
Let me check on that date. Myrna, do we have that date available in 2024 for a special setting? That would be the 14th, voir dire, 17th, we would begin evidence.
It is available, Judge.
Okay, so let's do that. Let's go ahead and set that as our, Mr. Grajeda, that I understood that you all were in agreement with that date.
Yes, ma'am. Yes, Judge. I'd provided those dates to Ms. Yamas before. Yes, ma'am.
Okay, so with that, 17th, let me get on the right calendar. 14th jury selection, 17th, Mr. Marufo, maybe we can try and get ceremonial court so we don't have to do it here in the courtroom. And then docket call will be on the 12th. We will do a final civil pretrial on May 15th. Beyond that, do you all want any other settings? Other than that, I mean, I think you all, we've been through this a few times now, so I'm not inclined to really, have you come back in unless you all have something that you specifically request a hearing on.
I might request that we move the final pretrial by a day or two. I'm getting ready to file my vacation certificates for 2024, and I think I picked May 15, but that we can do that later, Your Honor. We don't need to take up your time doing that right now.
We'll just bump it up to the 1st of May. Is everybody available on that date?
Looks good for me, Judge.
Thank
Thank you.
Unless I'm in trial, I have a setting on but we'll see.
No worries. No worries. We'll stick with that date and go from there. We'll have a little bit of room before the trial setting. Anything else? Okay.
Nothing, plaintiff, Your Honor.
Thank you
Your
very
Honor.
much. Myrna, we can go ahead and cancel out that October 18th and October 20th for the special setting now in June. Yeah, June 2024. Thank you. If you don't have anything else, you all are excused.
Okay, thank you, Judge. Bye-bye.
Take care. Who's next?
Second on page 3, Judge. In cause number 2021, DCV 2367, Donna Moore versus Laura Macias and Guadalupe de la O. Announcement of counsel, please.
Alejandro Acosta for the plaintiff, Donna Moore.
Good morning, Your Honor. Jessica Mendez on behalf of Guadalupe and Jose de la O.
John Dickey for defendant, Laura Macias.
Oh, Mr. Dickey, I can't hear you.
Oh,
Oh, there we go.
can you hear me now?
Oh, no. Deborah Lee is telling me absolutely not.
Okay.
Very strange. Give me a second.
Can you hear me now?
Yes, sir. All right.
No?
Yes, we can, Mr. Dickey. You'll go ahead
Sorry,
and.
Judge. Yeah, John Dickey for defendant, Laura Macias.
Okay, and so we are here for a final civil pretrial. Ms. Mendez entered just, about a month ago. How are we doing on this one? What are we doing? Let me see. End of October trial setting. That's not going to happen, right?
Yes, so Judge, it's a 3-car pileup. We're alleging that Mr. Dickey's client initiated the crash, ran into Ms. Mendez's client, who ran into my client. So I don't want to speak on behalf of Ms. Mendez, but from my client, Mr. Dickey and I have been talking informally, and we're hopeful we can try to get something done. If not, we have a mediation set on the 16th of October.
Okay.
Hopefully all parties can resolve it if we can't do so before that date.
Oh, well, I appreciate your optimism for you all being on top of that. That's not usually what I hear. So good luck. We'll leave. Is there anything else? I mean, I'll leave everything as is. See if we hear something back and things don't get resolved. We'll maybe you all can pick some dates or something going forward if that's what you're need to do going past the trial setting. Okay.
That works for us, Your Honor.
Mr. Dickey,
Yes,
Ms.
Your Honor, that's
Mendez.
fine.
Beautiful.
That's fine.
Thank you so much. We'll see you at the
Judge.
next setting. Next setting is the doc hall. Thank you.
Thank you, Judge.
Bye-bye. Who's next?
Bye.
Towards the bottom of page 3, Judge. Because number 2021, DCV 3473, Yaria Vasquez versus Gabriela Ruiz. Announcement of counsel, please.
Good morning, Your Honor. Gabriel Bettis on behalf of the plaintiff.
Good morning, Mr. Bettis.
Good morning, Your Honor. Joe Garcia on behalf of Gabriela Ruiz.
Okay. Final civil pretrial. I believe I received a few
Yes, sir.
pretrial motions. Let me mute that. And it looks like, I guess we have a summary judgment hearing in October as well, preceding the jury trial. Everything on track?
Looks so
Your
far.
Honor, the only thing, as far as the summary judgment, yes, Judge. The trial date, Judge, I know it's set for the 20th. Just to give the court notice, I have 2 other settings in the 41st District Court at the same time for the same day.
Mr. Crisco, we're right next door to each other, so that should work out pretty well.
Well, I can maybe do one witness and jump to the next one over, and I mean, whatever it takes, Judge. I do think one of those might settle, Judge, but I'm not sure about the other one, but we'll still keep working towards that date and see what we can get.
And Joe, the other case you have is with me. We're set on the
Oh, is it?
21st. Yes.
Okay. Which
Mr.
one is that
Garcia,
one?
you're gonna be surrounded by Bettises. You got Judge Bettis here, Judge Bettis over there, and Gabe Bettis on two of them. How about that?
Well, you know, that's,
And I'm a Garcia too. What's up with
there
that?
you go. There you go.
All right,
Okay,
so
well,
we
Gabriel,
have
so
our
we'll have to
settings.
decide on one of those then, huh?
I'll leave that to you all. I will see you on October 11th for the summary judgment hearing and see if anything has changed and what, if anything, we need to do about a trial date. How's that?
Sounds good.
All right, we'll see you then.
Thank
Perfect.
you, Judge.
Take care.
Bye-bye.
Who's next?
Right above that, Judge. In cause number 2022 DCV 0153, Valley National Bank versus RA Transportation LLC. Announcement of counsel, please.
Morning, Your Honor. Joachim Soderbaum here for Valley National Bank.
Is someone here on behalf of RA Transportation?
Your Honor, I spoke with Mr. Miranda on the phone, but prior to this, I'm covering for my colleague Chris Brown today, but Mr. Miranda reached out and let me know he's in a car and he was going to pull over and try to connect, but he wanted to let me know in case he wasn't able to, so that we had connected before. And it seems like he hasn't been able to connect.
Let me see, do we know? No, none of those look like they are.
Judge, may I?
Yes. Mhm.
I just spoke with their office and they said that Mr. Soderbaum would represent both of them on this. They had already an agreement, I believe. Is that
Okay, Mr. Soderbaum.
Yes, Your Honor. So we did speak and we were in agreement with what I could freely represent to the court. And the parties have reached a settlement of all matters. There is an issue with so far just with the initial payment of that. So we would ask if the court would please release the current November trial date and just let the parties work out that initial performance. And then hopefully we could follow up and promptly get this off the court's dockets.
So what I'm going to do is I'm going to leave the settings as is, notating that you all have settled. We have a final civil pretrial on the 18th. I will see you all on the 18th. Obviously, likely we'll just pull those trial settings, and if you let us know ahead of time, we'll just check with on the 18th of October. We'll see you then. Okay.
Thank you, Your Honor.
Thank you. Have a good day. Who's next?
bottom of page 3, Judge? In cause number 2023 DCV 1115 del Bravo Inmuebles de RIDCV versus Emilio Timblight Laboratories. Announcement of counsel, please.
Mr. Marufo, let me just stop real quick. Before we get to that one, is there anyone here on the top of page 3 on Wilmington Savings Fund?
Yes,
Or
Judge.
is that one?
I was just waiting for Mr. Jones to log back in because he was logged out, but I see he's back.
Let's take care of that one first, and then the one that's on, let me see, page 4. I think the one on page 5 has been.
Morning, it's Marina calling from the 2 Gym. I don't know if somebody called. We had an incident.
Let's take care of at least that one before we get into Mr. Madrid and Mr. Walker's case.
Yes, Judge. Let me bring. Okay, Judge. In cause number 2022 DCV 0662 Wilmington Savings Fund Society FSB versus Charlie Jones Jr. et al. Announcement of counsel, please.
Yes, Your Honor. Travis Gray, attorney for plaintiff Wilmington Savings.
Mr. Jones, are you here for this case? If so, if you could please unmute. And I believe, is this going to be Valerie Nicole Jones as well?
Yes, ma'am.
Okay, could you just please, one at a time, starting with Mr. Jones, state your name for the record?
Charlie Jones Jr.
And ma'am, what is your name?
Valerie Nicole Jones.
Okay. Is there anyone here on this cause, Wilmington Savings Fund Society versus Charlie Jones Jr., Charles Anthony Jones, Aaron Nathaniel Jones, and Valerie Nicole Jones? Nope. Okay, Mr. Gray, you may proceed. We're set for a default hearing today. Is that right?
Yes, Your Honor. As you know, this case has been pending for a while. We've non-suited every party that's disclaimed an interest. Myself and ad litem entered into an agreed interlocutory interim judgment as to the unknown heirs. There were 4 remaining defendants that you mentioned: Valerie Nicole Jones, Charles Jones Jr., Aaron Nathaniel Jones, and Charles Anthony Jones. They were all served in June. Their responses were due July 17th and the 31st, and no answers were filed. So we moved for interim default judgment and then incorporation of our agreed interlocutory judgment for a final order allowing just interim foreclosure of the property. No monetary relief is being sought.
I'm just looking very quickly. I may have received it via email, but
Yes, Your
I
Honor.
was looking through Odyssey very quickly at the document. Mr. Jones, have you seen the motion for default filed by Mr. Gray?
Oh, yes, I have.
Okay, Ms. Jones, have you seen that one as well?
Yes, ma'am.
Were you all intending to respond to that in any way?
Yes,
Mr.
well, the thing was when I had first called the Boyle Corporation, they didn't want to give me any information. They wanted me to sign papers before they gave me any information. And I had, since the very first court that I had with Judge Moody, with Mr. Gray, at that time, on the attorney's part, I guess they had no knowledge that they had a court date that date, so that they had rescheduled. And I guess that's why we're here today for that reschedule, because it took a while. And when I called their office, they asked me for some information. I gave it to them. They asked me for some documents, and I sent them to them. And I asked, what was I need to do? They said they couldn't give me no information unless I signed papers. And my thing was that I could not sign something that I was not going to. I want to see how I can do it to save the property, because my wife and I had been. I mean, we invested money into the property to save it while my mother-in-law was still alive. So at that time, so we did what we did to save. So all of a sudden, there was a loan brought out of the house where one of the other siblings on my mother-in-law's side, and it was never paid off. And at that time, I can't remember the loan company that they had gotten the loan from. It was a City Financial, I believe, started sending letters that the house was being in default. So my wife intervened and started finding out, looking into see what was going on, and found out that someone had taken out a loan. One of the siblings had taken out a loan on the house with the mother for whatever reason, and she just decided not to ever pay it back. I guess, I don't know. So my wife got the letters in the mail stating that there was going to be, that the house was in default, the payments were late. So my mother-in-law finally explained to my wife what was going on. So my wife and I, in order to save the house.
Mr. Jones, let me ask, who's your wife?
My wife is Maria Luisa Jones. She's deceased.
Okay.
And so with her and me, so we the ones that who had to go into bankruptcy to save it. So we did 5 years of bankruptcy. In the first 5 years of bankruptcy, they sent a letter stating that the bankruptcy was covered. So we were okay. So we thought, well, the 5 years were done, that whatever loan was due was paid. But then 2 months after that, receiving the loan that was paid off from the bankruptcy, we received another loan from the City Financial stating that there was a payment late. So my wife and the attorney, they looked into it and found out that at first they thought it was an equity loan, and it wasn't an equity loan that they had borrowed on. They actually got a mortgage loan. So I guess they got more money on the mortgage loan. And so we had to refile bankruptcy again. So in the process, we did the refile bankruptcy. So from the time that before my wife passed, from that time on, we had been paying. And then my wife passed and I continued to pay. And then I got together with one of the siblings and we talked about how we can do it to save it. And they agreed to help, but then all of a sudden they just, boom, everything just like no communication or nothing. So I'm like, okay, I go, I'm out of money. So how you guys want to do this? You know, so, but when I went with the Jack O'Boyle, their firm, when I would call to ask for information, they would tell me that they wouldn't give me information unless I signed papers. And I told them, I cannot be responsible for something that's not in my name. I go, I've been doing everything I can to save. I go, I've been paying on this bankruptcy, I've been paying, but you know, and now something, I'm out of money now. So that's why it's in default, because it was being paid on time back then until the year after my wife passed. After my wife passed, it was still being paid. And then we had the fallout with those siblings. And then from there on, it just stopped being paid.
Right.
But I couldn't, they didn't want to give me no information unless I signed papers. And I said, I can't sign no papers to be held responsible for something that I'm not responsible for.
Right, Mr. Jones, I take it by you being here, are you seeking any kind of legal assistance in this case to handle this matter, or are you just going to represent yourself?
I'm representing myself.
Okay. I'm going to mute you just for a second. Ms. Jones, if I can get you to unmute. Did you have anything to add or anything in response to their motion for default?
No, ma'am.
Okay, thank you very much. Mr. Gray, do you have anything else for the court?
Nothing further, Your Honor.
Okay, I am going to further review the motion that was filed. I think it's been filed for a minute, but I want to look at a few things. So I am going to take this and what I've heard today under advisement. I shall have, Mr. Gray, we have quite a bit going on right now. So I'm going to give myself a deadline of 30 days to make a decision here, okay?
Excellent. Would you like me to, I think we may have already emailed a proposed order. Should we send it again to the email address on your website?
I would say no, because I feel pretty comfortable that I've received it in the email. So it's just a matter of me searching. It was easier for me to do Odyssey right now.
Okay.
All right. So on this matter, we are adjourned. Thank you for your time, Mr. Jones, Ms. Jones, and Mr. Gray. Is there, I see Mr. Hoagland is here. Maybe on that one, we can be pretty quick.
Yes, Judge. In cause number 2020 DCV 0717 Arco Construction LLC versus Ricardo Baca et al. Announcement of counsel, please.
Corey Hoagland for the plaintiff.
Your Honor, Scott Mann for the defendants, Able Construction, as well as Merchants Bonding Company.
We're set for status conference. Let me get into this case. Wow, Odyssey is really slow. All right, status. Let's see. This was okay. How are we doing? How about somebody give me a status?
Judge, what happened here is my client is a subcontractor to a subcontractor to Able Construction. And we got a judgment against the subcontractor who hired us. I severed it out, made it a separate judgment. The client hired Ed Bunn to pursue the subcontractor, Ricardo Baca, and they went through all sorts of discovery games. And finally, Mr. Baca filed a Chapter 7 bankruptcy in April or May of this year. I didn't want to push the case against the general contractor and the property owner, who's now the bonding company, until we had exhausted all remedies against the party we had contracted with. We've now exhausted our remedies against the party we contracted with. So we're left with going after the general contractor and the property owner. I contacted the client. I've not heard back from the client as to whether or not he's going to want to pursue this to a trial, but I'm assuming that until he tells me no, he's going to want to do so. We have not done discovery against the general contractor or the owner. but we only need to do limited discovery, in my opinion, before this case would be ready for trial. I assume, unless Mr. Mann wants to do it to a jury, that we would agree to do it to the bench, to you, Your Honor. And it wouldn't take long to get it ready and try it.
Mr. Mann, is that, are you in agreement with that in terms of setting up a timetable here?
Your Honor, I think that's generally true. I anticipate doing some limited written discovery and maybe take a deposition or two, maybe just one of the representative, the corporate representative. I need to check with the client. I'm okay with a bench trial, but that's something that I would need to just get permission about. And then I think we're ready to go. We certainly anticipate filing a motion for summary judgment.
Okay.
What?
Why don't we utilize this in as a scheduling conference as well as a status conference? I'm just looking quickly at 2024. I would propose, I hate to do it, but summer is it's just kind of where we end up. July 19th, 2024. I want to use that as a target. Generally, that would be for a jury trial, but I want to give that week as kind of the idea of when we would do a bench trial. How long do you think you would need for a bench trial if we were there?
One day.
One day. So for now, we'll put it, well, let's do the 18th then. We'll do July 18th. Because if it is just a bench trial, if we get there, then that still frees me up for jury trials on the 19th. So we'll do the 18th. I'll have you on July 10th for a docket call. We'll get you a scheduling order. If you all will fill it out, return it, all that good stuff. I don't recall if in all of that you said you all had mediated. If you have not, there'll be an order to mediate the day before the final civil pretrial. So we'll get you the scheduling order, folks, and see where we go. If something changes and we don't get there, so be it. If you all want a jury trial, though, let me know because I will have to secure, well, we'll have panels, but it'll be in a change of date, voir dire on Friday instead of that Thursday, okay?
Yes, Your Honor.
Thank you very much. Y'all take care.
Thank you, Judge.
Thank you, Judge.
I think I see are folks here on the case on page 5? I see Mr. Paxton, and I'm just not sure if he's on more than one case.
Judge, there's a couple of individuals haven't identified. Ms. Kramer, are you there?
He's on.
Yes, I am.
What cause number are you here on, ma'am?
I am here on the M-Glo Bravo matter, 2023 DCV 1115.
Okay.
Your Honor, she's with me.
Okay, thank you. Mr. Moore, Mr. Jacob Moore.
This is Hugo Madrid. Mr. Moore is with me on this Anglo Bravo case as well.
Okay.
So I understood. I want to make sure if anyone is here on 2022 DCV 0886. Mr. Paxton, are you the only one?
Judge, I'm here on Duran versus Total Mechanical, which is 2022 DCV 3316 with Lily Talamantes.
Okay. All right. I hate to keep pushing Mr. Walker and Mr. Madrid back, but it's only 10:30. Let's see.
We're okay.
Okay, thank you. Because I kind of figure I'm, no offense to anyone else, saving the best for last year. So let's take care of everyone else.
In cause number 2022 DCV 3316, Jacqueline Duran versus Total Mechanical Inc. Announcement of counsel, please.
Attorney Paul Savna for the plaintiff.
Kurt Paxton for defendant. And Judge, I'd also like to introduce, normally we used to do this in person, but I guess we're in the Zoom world now. Lily Talamantes is one of the new attorneys in our office. She's online as well.
Oh, good morning, Ms. Talamantes. Welcome. Nice to meet you. One day we'll meet in person.
Good morning, Judge. Thank you so much. Nice to meet you as well.
We are scheduled today for a scheduling status conference. How about somebody, Mr. Savinoff? Are we ready for a trial setting and a scheduling order?
Judge, I would say not yet. We're moving in that direction. Plaintiff's deposition has already taken place. We have agreed on a mediator. We've agreed to mediate with Chris Ancliffe, and we're just finalizing and getting that mediation scheduled. Hopefully, we can get it done in the next several months, pending his availability.
Mr.
Judge,
Monday.
I'd ask that we do go ahead and get a scheduling order entered, Judge. This is a case of contested liability and contested damages. There's some special facts about this. I thought it was just a meat and potatoes accident, and then the more I find out, the more I'm very curious about what happened after this accident.
Okay, so I'm gonna, let me ask, I see there was an amended petition on July 26th. Have the special exceptions, I have a notation here regarding some special exceptions. Has that been resolved?
Probably not, Judge. For instance, I'm looking at 6.1 item J. It says violations of Texas Transportation Code. So I guess that'd be the entire book that would be introduced as a act or admission of negligence. We're entitled to a little more specificity. We're entitled to fair notice as to what they're going to claim we did wrong, Judge.
Okay, so here's what we're gonna do. Since we have not had a hearing since that last amended petition, let's start here. Let's start with the scheduling order. Trial date, August 9th, 2024. Docket call on the 7th. Sounds like you all already have Ancliffe as an agreed mediator. If you all fill out the scheduling order, we'll get everything scheduled accordingly, return it to the court. If you all are asking for an additional follow-up hearing on any special exceptions, or you intend to file new special exceptions, please, if you're filing something new, send it to Mr. Hernandez via email and we'll get that hearing set.
Judge, you said what date for pretrial?
I didn't say it. It'll be about 30 days before August 7th. It's just kind of how things fall.
Okay, but August 7th is the trial date, correct?
Correct. Mm-hmm.
Judge, I thought you said August
sorry,
9th, which would be the Friday.
August 9th. August 9th is the Friday. I've only had half a cup of coffee, Mr. Savinoff. Don't confuse me.
No worries.
The 7th is the docket call, so it's always the Wednesday before the Friday. And then the final civil pretrial is 30 days before that. The mediation deadline will be before the final civil. Okay.
Judge, we'll be settled or we'll be ready on that day, Judge.
Thank you very much. We'll get you the order. Take care, guys.
Yes,
Thank you,
Judge.
Mr. Alamante. Bye-bye.
Judge, may I?
Uh-huh.
Mr. Paxton, Mr. Paxton logged off, but the one you were talking about earlier on page 5, Judge.
Uh-huh.
We had received an email that was forwarded by Myrna.
I know, I read it. That's why I wanted to make sure they were passing on the motion to compel. I wanted to make sure nobody was waiting.
Yeah, okay, Judge.
Okay, thank you. Who's next?
I believe we can do that. The last
Let me-
one, on page 3, Judge.
Let me stop for a second. Ms. Deborah Lee, you need a break? No? All right, let's go then.
Okay, Judge. In cause number 2023, DCV 1115 del Bravo Inmuebles es del RL de CV versus Amicolo Kimblike Laboratories. Announcement of counsel, please.
Your Honor, good morning. Hugo Madrid here for the plaintiff del Bravo Inmuebles SDL LDCB.
Good morning, Your Honor. Mark Walker and Heather Kramer here on behalf of the defendant Amglo Kim Light Laboratories. I think that Ms. Kramer's motion for mission pro hac vice is still pending with the court.
Did we receive anything?
I believe so. So I just want to make sure we follow up and we'll make sure the court has whatever the court needs.
Okay. I don't see it, but I'm not always 100%, put it that way. So in any event, Mr. Walker, or is it Ms. Kramer? You may proceed. We're set for a motion for new trial.
Thank you, Your Honor. Appreciate it. May it please the court.
Yes, sir.
I'm here for a motion for new trial to set aside a no answer default judgment that the court entered on July the 31st of this year for just under $200,000. This relates to a dispute between entities that have premises and operations in Juarez. There is currently pending a lawsuit between the entities in Mexico. There is currently a situation in which they're in the dispute. Anglo-Chem is depositing rents in a separate account. And so there's this ongoing dispute. But what we're here about is the fact that regardless of the ongoing dispute, the plaintiff Del Bravo in Webness decided to go ahead and sue Anglo-Chem Laboratories and sought and obtained a default judgment without an answer. Now, there are two principal reasons why the court should set aside that default judgment. One of which is that the judgment's void, simply that the plaintiff failed to strictly comply with the rules of service. And as the court knows, if you fail to do that, then the judgment's void. The second is that on the Craddock Sunshine bus lines case, that the equitable principles apply and would need to be set aside anyway. So let's talk about the fact that they did not obtain proper service on AmGlo. There's a fellow named Ed Skelly, who is a registered agent for service of process, who is in a town called Bensonville, Illinois. The plaintiff chose not to obtain substitute service or anything, but decided to proceed with service by certified mail. If you do that, then you have to make sure that you deliver to the right person and that you get that person to sign the green card, and that the green card must be attached to the return of service to prove that you actually served who you were supposed to be serving. Well, what happened in this case is that apparently they never delivered a copy of the petition and citation to Anglo-Chem. Now, in support of our motion for new trial, we have a declaration from Mr. Ed Skelly, who is an officer of the company as well as a registered agent for service, and he sets forth how he came across information with doing some other research and found out that there had been a lawsuit filed, and this was after the court had already rendered the default judgment. So at any rate, he after finding out about the lawsuit and finding out about the default judgment, researched and found no evidence whatsoever of service of that lawsuit upon Anglo-Chem. Now, after midnight last night, Mr. Madrid filed a response to our motion, which has been on file for a while. The principal issue that he raised there was, well, that there's information, Mr. Skelly's declaration, about an address at 215 Gateway Drive instead of the correct name of 215 Gateway Road. Well, we just filed a supplement to the motion for new trial, in which Mr. Skelly makes it clear that wherever he said drive, he meant road, and that in fact there is no such other street such as Gateway in Bensonville, Illinois. There is no other 215 Gateway anything. There by Parkway, street, anything that you want to call it, there's nothing else. So at any rate, he conducted research, found that there is no evidence of that lawsuit in their offices. In fact, when you take a look at the court's file in support of the motion for default judgment, there is not even a green card. So the plaintiff in the motion for default judgment did not establish that they had actually served the lawsuit on Anglo-Chem at any address anywhere, or upon Mr. Skelly or anybody else who is authorized to receive service for AmGlo. And of course, that is their burden. They have to show that upon seeking a default judgment. They didn't do that. You have to show in the return of service that the lawsuit was actually served upon the person who was supposed to be served. Their return of service talks about having mailed it and attaches a copy of the white receipt that you have, but they don't attach a copy of the green card, which would show somebody who has actually signed for that lawsuit. So the declaration of Mr. Skelly has made clear that they never received it. There's nobody anywhere in the office of Anvil Kimlight who received that lawsuit, and the plaintiff has simply didn't establish, because it didn't do it, that they served an agent for service, nor did they prove service upon the agent. So for this reason alone, Your Honor, the judgment's void and should be set aside and a new trial granted.
Mr. Walker, can I stop you right there really quickly? I'm trying to keep up with your argument and then kind of cross-reference some of these things that you're mentioning.
Yes, Your Honor.
And I don't know if I'm going to be able to specify completely accurately. I can tell you on Odyssey, in terms of the motion for default judgment, it looks like page 51, there is a green card there that
Right.
is that and it appears to have a signature. Is that
That
you're
was
suggesting?
for, there is a January letter from prior counsel for
Yes.
John Dickey, prior letter. So they sent that letter, and so that's what that is for. So there was a certified mail receipt. That's what it would look like if they served the lawsuit properly. So that's what that's for. I looked at that at one point. I thought, what the heck is this? Did this not? No, that's what it was for. That's for that.
Attached to a letter. Got you.
If
Thank
you look
you.
at if you look at the dates that
Mhm. Thank you.
Okay. To proceed. Okay, so this really ought to end the inquiry here. The judgment's void. We don't need to talk about anything else, but we can. And so if the court wishes to consider the Craddock versus Sunshine bus line factor, will do so. One, that the failure to appear is not intentional. So again, wherever it was, whatever you want to call the road, street, drive, it doesn't matter, because it's 215 Gateway in Bensonville, Illinois, and there is no other gateway. There's no somebody else's office or other offices in Bensonville. There's no other 215 Gateway of any type of persuasion. And so Mr. Skelly's made clear that they searched the offices and nobody had it. So this is not a situation where somebody actually received the lawsuit. This happens sometimes where somebody at the front desk receives it, sticks it somewhere or another, whatever it is, but that didn't happen. I don't know what the mailman did with the lawsuit materials. I'm sure the court has had these experiences as well, where you just can't explain what the mail delivery people do with stuff. They go to the wrong places. They deliver to somebody next door or someplace else, and there's no accounting for that. And that's why it's so important that we have strict rules concerning the service of process. So they weren't expecting the lawsuit. We knew that the counsel for the plaintiff had the contact information for Mr. Skelly and never notified them, well, we've got a dispute, we're filing lawsuit, and here's a courtesy copy. Nothing like that ever happened. So when you look at the first of the Craddock factors, that's satisfied, because not only was failure to answer not intentional, they didn't receive it. And so there wasn't any, there's no accident or mistake. We failed to answer. We didn't calendar right, anything like that. It's just they didn't receive it. They're also required to set up, not prove, a meritorious defense. And if the court has questions about details of that, Ms. Kramer can answer those. But there is this lawsuit in Mexico that is an ongoing dispute. It's clear from the declaration of Mr. Skelly that they are not in breach, that they disagree that there's any breach of any guarantees or of leases, that they have set up the facts to support the defenses against this lawsuit on the guarantees, and in fact have shown that any rents in dispute are being deposited into a separate account. So those there. And finally, we've also offered that we don't believe that they're setting aside of this default will operate in prejudice to the plaintiff, in part because they never sued and never served the defendant. And also the way it works is that If there are some reasonable expenses associated with taking the default, then of course Anglo Chem Light will be more than willing to pay those reasonable expenses. So, Your Honor, again, because there's a failure of the duty to properly perfect service on the defendant, the judgment's void without further discussion. But upon further examination, if the court wishes to do so, we satisfy the Craddock factors and respectfully ask the court to set aside the default judgment and grant us a new trial.
Thank you, Mr. Walker. Mr. Madrid?
Honor, good morning. I'd like to begin with the premise of Mr. Walker's argument in terms of the service. Okay, now, Your Honor, the defendant is here represented by at least 4 attorneys. Okay, and so when the unsworn declaration of Edward Skelly was prepared, all throughout that declaration, if you notice, they kept referring to the address, basically saying, we never received anything at this 215 Gateway drive was what they, they hammered in on, honed in on, Your Honor. However, it was not until I brought this to their attention, okay, Judge, that they went ahead and said, oh, you know what, let's, either this was by mistake or it was intentional, whatever the case was, Judge, had it not been brought up to the court's attention, I don't think they would have, the court, and no one would have ever been able to figure out that they were referring that service was affected at a different address, Your Honor. Okay, and that was our concern here, because throughout the entire declaration, Mr. Skelly repeatedly stated that he never received any papers at this Gateway Drive address. All the investigations had taken place at the Gateway Drive address, when realistically he should have averred that the investigations took place at this 215 Gateway Road address. Okay, Your Honor. So that's an issue here that we have, because have not disputed that service was improperly done over at the 215 Gateway Road address. Now, Judge,
hold on, Mr. Madrid. Let me stop you right there. I think what I understood Mr. Walker saying is that with respect to the default judgment as filed, that their service was defective because there is no. So I want to hear that first, please.
Okay, that's where I was going to jump to, Your Honor. Thank you. If you look at the citation return, which was filed by Ivana Natividad, in there, Judge, you do know that, and actually when the citation was sent out, Judge, they actually sent the citation and the petition by restricted delivery. Okay, to Mr. Edward Skelly. And so when the case law says if it's restricted delivery, Your Honor, then no one could have signed for these specific documents other than the intended recipient. And you do see that there's an affidavit from the process server specifically stating that. Now, if you also look at the return, Judge, it has been filled out by the process server. Now, we do have on file a copy of the receipt. Now, Mr. Walker has alluded to the fact that it's got to be this green card. We do have the receipt, the return receipt on there that reflects that it was delivered and it was signed for, Your Honor. I also attached to my motion as exhibit, as exhibit I, Judge, the proof of delivery, which actually has a signature on there, Your Honor, that was delivered at 215 Gateway Road. Okay, now, Mr. Skelly repeatedly states that no one signed for anything. Now, he also states that he has never authorized anyone to accept any certified mailings on his behalf. However, Judge, someone signed it. It has been signed off on as far as the delivery there at the 215 address, Your Honor. So again, we restricted delivery, and this was before my involvement, Your Honor. Mr. Dickey was the one who filed the lawsuit, but on there it does state that restricted delivery was sent in. So, service was accomplished here, Your Honor.
Let me hear from Mr. Walker on that, please.
Your Honor, that's just incorrect. So the return of service says that the process server sent the lawsuit by certified mails to restricted delivery, includes the little white card that says this is the number of the green card, this is how it's sent, but they don't include the green card. So there is nothing that shows that the lawsuit itself was delivered to Mr. Skelly or Anglo Chem Light. So that's all that's required. And the whole issue of road versus drive is a distinction without a difference. There is nothing else. There is simply this one address, whatever you want to call it. You know, I can't even remember whether the street I live on is a drive or a street or whatever. I just know what the address is. But regardless, they would have had to have shown the court that here's not only do we send it to them by certified mail, but they actually received it. And here's the signature on the receipt for that lawsuit, not a January letter, which is attached to the motion at the end. And just a quick cursory glance at that shows a different date. So, Your Honor, for this reason alone, the service is defective, the judgment's void, and should simply be set aside.
Mr. Madrid, if you have some more on that, if not, you can continue.
Mr. Walker is asking this court to accept is, you know, if this, how would we ever, you know, Mr. Walker saying, well, you've got to specifically have Mr. Skelly's signature on here. Parties do this all the time, Judge. How would we be able to figure out whether someone really did sign off for this on this certified letter? Now, Judge, the process server's affidavit is conclusive proof that it was sent by restricted delivery to Mr. Skelly, Judge, and that's what the law requires. It was sent restricted delivery, wasn't generally sent to, you know, whoever signs off on it. It was specifically restricted to Mr. Skelly, and the fact that they're claiming that that was not the case is just completely incorrect.
Your Honor, I've been doing this for 38 years. We used to go to the court, and you had their green card on file. With the documents in the court, we would approach the bench and the court would take a look at the green card, make sure it's stapled to the return of service. And so we've been doing this for a very long time, that if you serve anybody in state or out of state by certified mail, you have to show that they actually received it. And simply having the return by the process server saying, I sent this to restricted delivery, but I haven't received a green card showing that somebody signed for it, is not proof of anything other than they sent it out. So you have to show that you actually received it, and you have to show that by proof with the return of service. So without that, and we don't have that, then there is no valid service on the defendant Anglo Chem Light Laboratories.
All right, Mr. Madrid, go ahead.
Your Honor, the other thing, I know Mr. Walker's been practicing for many more years than I have, Judge, but again, the restricted delivery plus, Judge, the other thing I do want to point out is that when this judgment was, when the notice of judgment was sent out to the defendant, that was received. Okay, coincidentally, the notice of judgment was received, but they are saying that the citation and the petition were not received. And to the extent Mr. Walker continues to argue that it doesn't really matter what the process server says, that's inaccurate. That's the law specifically says that process server's affidavit is conclusive proof.
Okay, but proof of sending, right? Yeah, I mean, ultimately, what the process server's affidavit says is that it was sent via restricted delivery, right?
Then we would attach to our motion, we attach copy that it was received, it was delivered to that specific address, Your Honor. And I also have attached the proof of delivery, which was not in my motion, but my motion for default, but in my motion here that I have filed in response to the motion for new trial that reflects that it was signed by someone.
Okay, can you point me to that? And I apologize, I received this when I got here this morning.
Yeah.
And so either way, whether I do it on Odyssey or I go through the hard copy, it's difficult to find. If there's an exhibit number, can you tell me what it is, please?
Yes, Judge, it is Exhibit I.
Okay. All right. Anything else on that topic?
No, Your Honor.
Mr. Madrid?
No.
Okay, then you can continue. I know I stopped you short there on some other matters.
That's I addressed. Those were what I addressed. I'm not sure Mr. Walker got into the Braddock issues if you wanted for me to address those, or whether you needed to first look at this whole.
No, Mr. Walker, then you can go back to the Craddock section. I thought we had covered that, but if you have it there.
I've covered that, Your Honor.
Yeah, I thought you had. So Mr. Madrid, you can proceed on that portion now.
So Judge, going us into the Craddock factors here is a couple of issues that we have here is that in paragraph 8 of the motion, again, this goes back to Mr. Skelly claiming that he had no knowledge of receiving the petition. I know we've already argued the issue as to whether, service was accomplished at 215 Gateway Drive or at 215 Gateway Road. Now, the other thing is that they contend that, okay, assuming that we did receive service of process, well, then it was lost. Then it was a mistake that we did not answer the petition. However, Your Honor, it goes back to the whole issue again, whether they received service at 215 Drive or 215 Gateway Road. Now, one thing that's very interesting is that Mr. Walker argued that the defendant wasn't expecting to be sued. Now, that's a bit strange because back in January of this year, Mr. Dickey, who was representing the plaintiff before I was, sent a demand letter, a notice, basically informing the defendant that under the guarantee, AMGLO Bravo was in default of its lease obligations. And in that same letter, a demand was made for the defendant to cure the default. Okay, Mr. Skelly, Your Honor, responded to that letter in February, I believe it was February 10th, where he essentially said, well, you know what, because we were going to purchase the property, and once we purchased that property, then we had no further obligation to pay any lease rents. So basically, Mr. Skelly contended that an agreement existed for the purchase of the property, and because my client allegedly did not go through with closing, and my client was in breach, and even though that the closing didn't take place, then rents were, basically said rents were still due. Now, Judge, Mr. Dickey specifically asked Mr. Skelly to provide him a copy of that agreement. Mr. Skelly, in his declaration, which is on file with this court, admitted that he didn't do so. Okay, so then a couple of months went by, and then that's when my client ended up suing the defendant. So to the extent that Mr. Walker continues to argue that they didn't know about a potential lawsuit, that's just completely false. They knew we had made a demand. They knew they didn't cure those obligations. They knew that my client still owned the property, and they knew that because they were still in the property that they had an obligation to pay lease rents, and they weren't doing so. Okay, and then the other thing is that Mr. Skelly states that coincidentally, Judge, on the date that you entered the default judgment, January 31st, that's when he found out about the lawsuit because he was coincidentally doing some online research. Well, it's awfully coincidental that on the same day that you entered the judgment, and that's when he found out about it by just doing some random research. Okay. The other thing is they claim that we should have notified or should have sent a courtesy copy of the petition to Mr. Skelly. I know no rule or any statute that specifically requires us to do so, Your Honor. I don't think that the defendant has argued that. Again, the other thing that I had mentioned is, they did receive notice of the default judgment, which was sent to the 215 Gateway Road address, Your Honor. Now, going into the issue of a meritorious defense, Your Honor, one of the concerns that we have is that Mr. Skelly specifically stated that there were certain conditions that had to be met before closing could occur. Mr. Skelly did admit that my client met those conditions, but nowhere in his unsworn declaration do you see that Mr. Skelly averred that the defendant had met those conditions, but yet they claim that my client breached the agreement, even though there's nothing in there that states that there was any issue, or rather that my client was in breach, even though my client, according to the defendant, met its obligations. Now, going back to Mr. Skelly's February 10th email, he specifically states, doesn't deny, Judge, that rents are owed. So the fact that he's claiming that rents are owed, the fact that he's claiming that he doesn't own the property, the fact that Anglo is still in the property itself and is not paying rents or has not been paying rents, that's, what defense is there? So I don't believe that what they're talking about as being a meritorious defense. I just don't think that holds water. Now, as to the final and third Craddock factor is Mr. Walker did state that they're prepared, that there's not going to be any delay or prejudice towards the plaintiff. But Judge, in there, they are not stating that they're ready to go to trial immediately. Okay, what they're saying is that after a short after short and reasonable discovery, the defendant would be prepared. But Judge, what's short and reasonable discovery? For us, it could be a few months. For the defendant, it could be a few years, or they could even contend that they can't go to trial until the Mexican litigation is resolved, Judge. So this isn't going to be a thing where, that we're not going to suffer any harm, Judge, because, they may try to contend that we can't go to trial until the Mexican litigation is resolved.
Your Honor, if I may,
Yes, sir.
if you still have the plaintiff's response to our motion for new trial called
Yes, sir.
up on your screen,
I do.
I'm looking at page 180, which is the USPS tracking, and it
Yes.
has. Are you with me?
Yes, sir.
Okay, so a couple things I want to point out. That even though the service was supposed to be accomplished by restricted delivery to Mr. Skelly. First of all, when you look at the typed up information, it says delivered to the front desk, reception area, or mailroom. I think none of those is Mr. Skelly, but more importantly, if you would take a look at the certified mail receipt at the top of the page, and those include the numbers specific to the certified mail that went out. So if you look just at the last 4 digits on that certified mail receipt, it says 2481.
Yes.
Okay, so that would be the certified mail that was sent at that time. Now, if you will, scroll up to page 176.
Yes.
Okay, now there is a copy of a green card that was directed to Ed Skelly, Amglo Chemlight. Let's take a look at the number on that certified mail receipt. The last 4 digits are 3554, right? And if you look at the receipt on the prior page, 175, that's also 3554.
Yes.
And that was for the prior correspondence. So the prior correspondence was delivered and signed for. And so to the extent that the plaintiff claims that somehow or another this prior certified mail receipt is proof of service on Mr. Ed Skelly by restricted delivery in May of 2023, that's simply wrong. So again, that is very helpful. This is why we take a look at that. We look at the information. 3554 is not the same as the certified mail that went out there that the plaintiff sent out, number 2481. So it really that disposes of the issues. We don't need to discuss more. We've addressed issues in anticipation of attempts to retain the judgment. I don't think we need to revisit those issues, but simply put, the plaintiff failed to deliver the lawsuit to Mr. Skelly, or frankly, for anybody else who's authorized to accept service, and failed to prove so. On that basis alone, the judgment's void and we're entitled to a new trial.
Your Honor,
Yes, sir.
almost sound Mr. Walker is claiming that we were trying to somehow mislead the court in stating that that certified green card was in fact what was signed off on by Mr. Skelly when he received the citation, the petition. Absolutely not, Judge. That is when Mr. Dickey sent the demand letter, that's what that refers to. I know at no time have we made reference or alluded to the fact that that was the green card that Mr. Skelly signed off on when the citation and petition were served on him. So to the extent that's what Mr. Walker was trying to represent to the court, I can tell you that's not the case. That never happened, Judge. I just want to make sure that the record is clear on that.
All right. Do y'all have anything else?
No, Your Honor.
No, Your Honor.
All righty. So I definitely need to review the response in opposition filed or provided to the court today. Unfortunately, I think I'm going to have to give you that same 30-day kind of timetable because of the court's unavailability for a good portion of the next few weeks. And I want to make sure I review everything. So I'm going to have us set for a status in 30 days. That's going to put us all the way to October 25th I'll use that kind of as my deadline, but for sure to have you all come back on a status if I haven't already reviewed, haven't already ruled. We can use that for anything, you know, if I decide I have more questions and need to hear from you all again, if we're going forward, if we need some type of scheduling status conference for whatever it is, it's going to be my 30-day marker. Do you all have anything else for the court today?
Just by way of housekeeping, Your Honor, we did file, since we received the response early this morning, we did file a supplement to the motion. And I don't know if you need for me to send you a courtesy copy of that. We'd be happy to do so.
I am seeing that. I don't know if it loaded up here, but it does not have a PDF. So if you can email it, if it's something you can email, I feel comfortable. Odyssey will eventually have something on here that'll let me click on to look at, but might expedite things, Mr. Walker. So yes, I do see supplement to the motion for new trial.
We will do that. And does the court want the parties to submit proposed orders?
Yes, please. That'd be great.
Very good.
All righty.
Thank you, Your Honor. We appreciate your time today.
Thank you for your time, Mr. Madrid. Anything else, Ms. Kramer? Thank you. Welcome. I did eventually see it was your information was in the filings.
Oh, good. Thank you.
Yeah, no, Your Honor, may we be excused?
You may. Thank you for your time.
Thank you.
Thank you all. Bye-bye.
All right. Mr. Saloon is here for who?
Bottom of page 6, Judge.
Aren't we missing?
No, Ms. Acapulco is here.
Oh, okay. Sorry. I was thinking of the other case with Mr. Lopez. All right.
In cause number 2023 DCV 1926, Security Service Federal Credit Union versus Mary E. Robinson Colwell. Announcement of counsel, please.
Mary Capo, attorney for plaintiffs.
Good morning, Your Honor. Nassim Saloom for the respondent.
Hey, let's see. Let me just pull this up. It's just very slow on Odyssey. We're set for a motion hearing. You need future dates. Can you give me an update, Ms. Acapo, on some status, or Mr. Saloon? As my case is loading up on Odyssey.
Yeah, from my end, we filed our petition back in, I believe, June to proceed with foreclosure. I know the defendant filed an answer, didn't allege or raise any specific defense. It's just a general denial. As far as I'm aware, I haven't received any correspondence besides, I believe, Mr. Saloom did request a payoff quote. I'm not sure when that was. I think that was shortly after the answer was filed regarding the amount necessary to pay off the loan. That was provided to him, but besides that, I haven't had any other sort of communication from him or from the defendant directly.
Okay, Mr. Saloon.
Yes, ma'am. And she is correct, Judge. Ms. Capo is correct. What's going on, Judge, is my clients are in the process of paying off Ms. Capo's clients. I spoke with the defendant's sister this morning, and she told me the funds have been gathered and should be wired within the next couple of days. That's what she communicated to me, and I'm hopeful once that's paid off, the plaintiff will just non-suit or dismiss this case. And that'll be the end of it, Judge.
Well, I don't know.
Sorry. The payoff quote I mentioned, that was requested back in I want to say July. That was requested last month. I'm sorry, August 16th is when you requested. And those payoff quotes are only good for 7 days. And so if your client is under the impression of wiring any funds, it would be insufficient as of now, because the quote provided to you was last month, and it was, it's past the 7 days. And so, like I said, I haven't received any sort of communication with regards to we're planning on paying it off, or we have the money together. We're just waiting on a couple of things. And so those communication will be necessary just on our end to, hold off on this hearing or provide the defendant more time to get that necessary. But I do know that any money or any funds trying to be wired to my client would be insufficient, as the payoff quote provided are only good for 7 days due to court costs and attorney fees and late fees and such that gets added on every day. And so we're still of the stance that we would like to proceed with foreclosure, just because no efforts had been made besides just requesting the payoff quote, no efforts have been made by the defendant to either reinstate their loan or pay off their loan since the notice of default was sent to them back in April and since the filing of our petition. And so we're here this morning just to ask the court to proceed with foreclosure.
Ms. Capo, what's the current amount, payoff amount? Do you have that?
I don't have that. And so it takes a couple of days to generate just because of the late fees and the interest. But I do know, I don't know if he has the quote that was provided to him as of August.
Yes.
August, yeah. So if he has that, that would have been good for 7 days after that was provided to him. And I know in our application, as of May, we had a little under 60,000 was what was needed to pay off their loan. To reinstate the loan will obviously be much less than that, but he asked for a payoff quote. And so whatever the number was provided, that would have been good as of August.
Your Honor, to answer your question, the payoff is roughly about 63,000. I'm sure it's a little bit more than that at this point, Your Honor.
Mhm.
And just so the court is clear, I've been attempting to effectively communicate with my client to get the lender paid off on this. There's and that's what we're in the process of doing. I don't want to send any communication until I can affirmatively know that the funds are being gathered and they're going to be sent to pay off a loan, Your Honor. So I think my clients in good faith are trying to in fact pay off the lender and put this behind them.
Well, but let's see. All right. So that was filed in June. We have an answer at the end of July, and here we are, September. Well, I will reset the hearing today for 2 weeks. Mr. Saloom, I don't know how you get together with your client to find out what amounts would satisfy or prevent foreclosure, but it doesn't sound, I mean, I know you're representing that and I don't, doubt you, but there's nothing concrete to say that, anybody's reached out to a plaintiff on this one. So I'm going to reset it for 2 weeks, get a number. If your clients truly are in a position to get it current, then you can let me know that in 2 weeks. If not, then we can look at proceeding on the expedited order foreclosure. Okay.
Okay. Thank you, Your Honor.
Thank you. Thank you for your patience.